কলকাতায় ট্রায়াল চলছে ট্রায়াল ডে বেসিস অন্য গেছে দাস সিটি সেশনস করে কোনো এই করছে না কোনো তখন করতে হবে এই করছে ও হাই করছে PC doc, he prays for statutory bail since FSL report has still not been filed. Paragraph opposing the prayer for bail, the state advocate says that leave has been sought for to file supplementary charge sheet with which FSL report will be filed. Stop. Commercial quantity of contraband items was seized from this petitioner. Stop. The bail prayer should not be allowed. Paragraph. We are bound by the division bench judgment referred to above. Stop. Admittedly, comma, even as of date, comma, the FSL report is not available. Stop. Hence, comma, on the 181st day after the arrest of the petitioner, comma, he became entitled to statutory bail. Stop. Therefore, we feel impelled to allow the bail prayer. Paragraph accordingly. এই ওইটা কিন্তু তোমার তুমি কখন যাবে চলে যাবো
And for the petitioner, your lordship, on the state. Lordship, present petitioner is languishing in custody since 860 days. Charge sheet filed on 19th of December 2022. And after filing of charge sheet, 17 dates has been passed, but till today, charge is not framed. And this is my renewal of my bail application. My application was lastly rejected on 12th of August 2024. And after the last rejection, and after
You're in custody for how many days?
860 days, and I am relying.
How many witnesses?
There are total 14 witnesses are there. Till today, charge is not framed.
You tell us what should we do in such a situation, particularly in the light of the observations of the Supreme Court.
I leave it to your lordship. My feeling is that last date was yesterday for framing of.
What
charge.
happened?
No, charge is not framed, and next
Nothing
date is fixed on 21st of December. For framing
What
of-
was seized?
Seized
But,
commercial quantity of
134 kgs of gaja.
gaja.
You think we want to give grant bail? We don't want to. But what do we do? Our hands are tied.
So the next date is fixed on.
2.5 years charge not framed.
I am relying to judgments of Ravi Prakash.
For rely করছি judgment. What judgment? এসো। আরে দেখি কি দিতে চাইছে দেখি।
So state Ravi Prakash versus state of Odisha.
The petitioner renews his prayer for bail, renews, which was rejected on
Rejected on 12th of August 2024.
August 12, 2024. Stop. He says that he is in custody for 860 days, i.e. approximately 2.5 years. Stop. He tells us that charge sheet was filed in December 2022,
19th of December.
on December 19. করে দাও। Stop. Till date, charge has not been framed. Stop. On the ground of delay in progress of trial, he prays for bail. Paragraph. Learned state advocate, comma, while opposing the prayer, comma, tells us that 125 kgs,
134.
34 kgs of ganja was recovered from this petitioner.
But the appropriate quantity is 134.165 kg. 0.165.
বাপরে বাপ। Approximately 134 kgs করে দাও। Approximately, from this petitioner. Stop. There is sufficient incriminating evidence against him. Stop. Yesterday was the date fixed for framing of charge. Stop. However, charge has not been framed. Paragraph. We are astonished to find that even after almost 2 years of filing of charge sheet, comma, charge has not been framed. Stop. There are 14 charge sheet named witnesses. Stop. The trial has not even begun. Stop. on the touchstone of Article 21 of the Constitution of India, comma, we feel impelled to allow the petitioner's prayer for bail. Accordingly,
Deeply obliged.
I am appealing for the petition. 8 kg of garlic.
8
8 kg.
kg. What is the stage? How many days in custody?
Custody is 50 days.
Oh, below commercial quantity.
Below commercial.
It is small or intermediate?
Intermediate. Small is 1 kg.
20 is commercial and intermediate is up to,
From 1 kg to
oh, below 1 is small. Yes, but that does not mean bail is automatic.
37
37 may not apply. Why should we grant you bail if there's incriminating evidence against you?
That's the state.
Yes, state, what do you say?
One thing, Lordship, the seizure was made in the month of September. Till date, inventory has not been put. Rule 13.
Why? The petitioner says that the seizure took place in the month of September, 2024.
19th of September.
On September 19, 2024. Stop. Till date, inventory has not been done. Stop. He is in custody for 50 days. Stop. 8 kgs, i.e. intermediate quantity of ganja was allegedly seized from him. He prays for bail. Stop. Paragraph. Opposing the prayer, comma, learned state advocate says that just because the bar under section 37 of the NDPS Act does not apply, comma, bar now restrictions, karo. Just because the restrictions in section 37 of the NDPS Act do not apply, comma, that does not mean that the petitioner is automatically entitled to bail. Stop. After all, contraband items were recovered from him. Paragraph, we have considered the facts and circumstances of the case and the material on record. Stop. We are surprised to see that even though seizure took place on September 19, 2024, inventorization has not taken place till date. Stop. We are.
Because that certificate was done on 21st of October, but the sample has come.
Has not been sent also.
Certification was done.
Right, but sample not sent to FSL. To FSL. Till date, the sample has also not been sent to FSL. Paragraph, under those circumstances, we are inclined to allow the petitioner's prayer for bail. This is renewal. 50 days in custody. When did you apply first?
So on 18th of October, I have
Renew his prayer for bail. Renew his prayer. Which was rejected on
15th of October.
October
During the
18th.
vacation.
Number 16.
Lord, I am for the petitioner in this case.
18th October তো ছুটি ছিল। Petition court petition এটা bail কে বলে।
Lord, the offences are under the provisions of NDPS Act. Lord, what happened? This petitioner, my lord, early in the morning went out for a morning walk. My lord, in a locality nearby, my lord, when he was there, my lord, he found some police personnel were searching something. And later on, my lord, this person has been implicated in a NDPS case. And my lord, this is the case of the police also, that he was found in the concerned place, and in that locality, a bag of gaja was recovered containing 27 kgs of gaja. And my lord, on suspicion, this person has been arrested.
It was not from.
Not from his exclusive possession.
His exclusive possession was
No.
not searched.
No. And
Yes.
my lord, one thing, my lord, in the FIR, the complainant says, the seizing officer says that entire process has been videographed in terms of the order passed by this honorable.
Kalu Sheikh.
Yes, and in the charge sheet, the investigating officer says that repeatedly I have asked for the video footage from the seizing officer, but he has said it has, due to technical error, the video footage is not available. My lord, I am in custody for my lord 223 days
Not
now.
commercial quantity, exclusive possession from this petition.
Exclusive possession
Exclusive.
from the seizure list, it is available.
Yes. From the verbal copy of seizure list, my lord, where's his signature also. And
At this stage, we will go by the Caesar list.
My lord will see the FIR there. In the FIR, they have said.
FIR এ কি বলেছে? আচ্ছা কি বল? ওদের ইয়েতে annex করা আছে।
My lord, this is the seizure list.
Oh, that means from the area where he was present, that area was searched,
Yes,
not that bag was beside him.
no,
The bag
yes,
which contraband was found, it was not beside him or within his control.
yes.
But in that area, after how many distance of
That is.
that is not there.
That is not mentioned in.
Distance from his
No,
standing and the
That is not. It is a matter of trial, your lordship, matter of trial.
My lord, even in the
What is the stage?
My lord, charge sheet submitted
Pending for charge.
along with CFSL report on 19th of September 2024.
now you
Just
see
prior-
there are two
prior-
inferences available that
Yes.
some persons left it and ran away by seeing the
Maybe.
police officer. That is also
That
possible.
can be, my lord, that can be possible.
And this person can also be
Yes.
involved.
That is totally matter of trial, your lord.
But-
At this stage, my lord.
Only
charge
the
sheet
only
submitted
thing
along
is
with
this,
CFSL
yes,
report.
yes, only thing.
You were
is this.
arrested when?
My lord, on 28th of March
yes,
2024.
20th of March. But
Within
200,
180 days you filed.
Yes, along with CFSL.
Lord,
14
charge
witnesses.
14
But,
witnesses, 14,
Next date,
14th of November.
14th of November.
For
For-
framing of charge.
For framing of charge.
But just prior Durga Puja vacation, my lord, charge sheet filed. Along with CFSL.
কি হবে 37 district কি করে দেবে?
মানে পজিশন পাইনি এরিয়া থেকে বেশি যেখানে
কিন্তু তোমার again ছিল, Supreme Court আছে। You can take again the question of that.
37 এটা
My lord, may consider just two things, that the video footage, my lord, is mandatory requirement now, and my lord, that has not been done, and that is there in the charge sheet. And in the FIR itself, my lord, they have stated that on suspicion and due to his presence in the area, my lord, he has been arrested.
Argue those things at the trial. The petitioner says that he's in custody for
224 days.
কত?
224 days.
24 days, 224 days. Stop. The seizure was not from his possession. Stop. It was from the locality where he resides. Stop. Charge is yet to be framed. Stop. He prays for bail. Paragraph. Learned State Council says that November 14, 2024, has been fixed as the date for consideration of charge. Stop. Approximately 27 kgs of ganja was recovered from the exclusive possession of this petitioner, as would appear from the seizure list. Stop. Paragraph, we have considered the material on record. Stop. Given the prima facie involvement of the petitioner and commercial quantity of contraband items being involved, keeping in mind the restrictions in section 37 of the NDPS Act, we are not inclined to allow the petitioner's prayer for bail, at this stage. Paragraph dismissed.
Good.
I'm grateful. My lord.
Please write it.
61, 61 not here. 62,
Lordship paying for not today.
63. 63,
My lord, I pray for not today.
64,
Lord, in 64, I appear for the petition.
64.
One accommodation is busy with his personal engagement, lordship.
65,
Oh, yes, he said so.
Yes, yes, lordship. So mother-in-law died and today is just
His mother-in-law died.
mother-in-law.
65,
65, I'm for the state.
Paying for water accommodation, Mr. Ganguly. Sadly, my says not.
You want not today? We will grant you not this week.
Grateful, mother.
Lordship, I will have to not press this application.
Oh, excellent news. लिखे दो. Learned advocate for the petitioner says that he has instructions not to press this application for bail, paragraph dismissed.
For the petitioner, in custody since 430
67 state,
430 days in custody, your lordships, charge sheet has been filed without FSL. And the statutory period of 180 days is completed on 3rd of March 2024. After that, supplementary charge sheet is filed on 15th of April 2020. So
Mr. Chakraborty,
my lord, CS was filed on 26th of 2nd, 2024. That is means the case started on 2nd of September 2020. So within 6 months it was filed. Now, my lord, actually the statutory period in NDPS cases, this first is 180 days,
yes,
which can be extended up to 1 year.
can be extended.
Now, later on, the charge sheet, the CFSL was received on 1st of March 24, just after 6 days of filing of the charge sheet, then supplementary charge sheet was filed. So within 1 year.
Before 180 days expired, did you obtain an order for extension of time
Obviously.
to complete investigation? Where is it?
Extension may be there, but then, requested time allowed to all the.
Lordships, it is filed after
No, to be charged, it fine for a time period extended.
হতে পারে but only 15 details we are 180 days হতে পারে investigation চলতে পারে but when you take the details we are 180 days without filing a statute.
Why not?
এটা হলো notice-এর কি বলা আছে
180 days হচ্ছে যেটা তোমার এখানে তোমার PRPC তে কি আছে বলো 60 বা 90
days
90 days.
এখানে 180 days
Data can be under the MPPS Act can be extended by another 180 days.
কিন্তু
এই extension এর মানে কি?
internal complete investigation
That means you can keep to custody. It is the case law আছে.
কিন্তু the decision আছে our period of detention cannot go beyond that.
after the
Yes, when?
extension of 180 days, supplementary charge sheet has been filed.
Sir, if he obtained an order prior to extension, expiry of 180 days, that he time to complete investigation and file charge sheet or supplementary charge sheet, as the case may be extended by 180 days. That is permissible under the NDPS Act.
Yes, your lordship, that can be.
Yes,
Is there any document to show that?
yes, Mr. Chakraborty.
My lord, regarding the extension petition, there is no such extension.
There is no such extension.
Then,
But,
then he has to be released. Have you followed what I'm saying? Had you obtained extension, the time period for investigation and filing of charge sheet would have stood extended by 180 days, which means total of 360 days.
he has filed the charge sheet without the FSL report, without
Yes.
the prayer for filing of supplementary charge sheet.
No, that is not.
But,
No.
extension petition is not done.
The petitioner says that the charge sheet was filed, though within 180 days from the date of his arrest, but without the FSL report. Stop. The FSL report was filed by way of a supplementary charge sheet much after expiry of 180 days. Stop. Paragraph, the state could not show us any order extending the time for completing investigation or filing supplementary charge sheet. Stop. Paragraph, the view of this court, as is reflected in at least 2 division bench judgments, is that a charge sheet filed without FSL report, comma, even if filed within 180 days, comma, is of no value. Stop. In such a case, comma, the accused becomes entitled to statutory bail upon expiry of 180 days from the date of his arrest. Stop. Paragraph, in view of the aforesaid, comma, we are constrained to grant bail to the petitioner.
Clear.
About the petition.
State lordship, one day accommodation.
For the petition.
Mr. Saurabh Ganguly is here.
70.
Well, if these two matters are fixed tomorrow,
69.
69 and 60.
Yes, tomorrow. Come tomorrow.
One.
Well, 70.
One day that.
71. 71.
I'm for the petitioner.
Why not? No CD. Today the CD, I have information, the CD has reached today. One day.
72.
His trial has not been Monday.
73.
My lord, 73 praying for not to try.
74.
For the petition. My lord, in this case, my lord, on last petitioner,
Yes, now.
your lordship was pleased to ask the state to serve the copy of the demand to complaint.
74.
Is the POXO matter, my lord.
এই বন্ধ করো
এই পক্সো ম্যাটারের উপরে
কোথায় পক্সো ম্যাটার?
Lordship charged under section 498A and 302, Lordship. Custody, Lordship, the petitioner is custody for 5 years, 8 months, more than, Lordship.
About 5 years.
And Lordship,
What is your relation with the deceased?
wife, Lordship.
No, you are what?
Husband.
Husband.
Yes, Lordship. And Lordship, there is a 28 witness, only
Report,
17
report,
witness is
report.
exempt.
State report. Tell us.
Lord, the report does not indicate how the delay has occurred, only says that 10 more witnesses are yet to be examined.
You need more witness, 5 years.
Hey, sure. The petitioner says that he is in custody for more than 5 years, 8 months. Stop. 17 out of 28
Yes, Lordship.
charge sheet named witnesses have been examined. Stop. He renews
Yes, Lordship, second time.
his prayer for bail on the ground of delay in progress of trial. Paragraph. Opposing the prayer, learned state advocate says that the charge is under section 498 capital A and 302 sections of IPC. Stop. The petitioner is the husband
Yes,
of the victim. Stop. There is sufficient incriminating evidence against the petitioner. Stop. All efforts will be made to conclude the trial on an early date. Paragraph. The prosecution may have an excellent case to secure the petitioner's conviction. Stop. Nobody stands in the way of prosecution, stands in the way of the prosecution. Doing so, stop. However, an under trial cannot be kept incarcerated for an indefinitely long period of time. Stop. That would be contrary to the principles enshrined in Article 21 of the Constitution of India. Paragraph. At the pace the trial has progressed so far, it may take a few years more for the trial to conclude. Stop. Hence, solely on the ground of delay in progress of trial affecting the fundamental right of the petitioner under Article 21 of the Constitution of India, we are inclined to allow his prayer for bail. Paragraph accordingly.
grateful, grateful, Lordship.
A report filed by the state be kept with the records.
Petitioner is custody about 2 years, 10 months.
What is the relation with the,
Relation, husband and wife.
no, this is the female accused
Wife, second wife.
and
This
Second.
is the husband.
this is the husband.
Yes. So only 5 witnesses was examined out of 12. There is no eyewitness, my lord. His sister lodged this complaint, my lord.
Yes, give the CD.
I have also.
The next date is fixed on 7th of December.
Yes, where is the 164 statement?
There is no eyewitness.
No, let him place the one.
Well, there is no 164 statement I find in the case diary.
No,
Only
161 statement.
161 state.
Okay, 161 statement of the witness.
Witness my lord, 19,
Yes,
my lord, 19, 19.
19.
Thereafter 35, 37 and 40. Five witness out of 12 has been examined.
You will examine all 12.
No, my lord, till date, my lord, 5 out of 12 has been examined.
Do you propose to examine all 12?
Lordship.
Okay, where is the postmortem report?
My lord, PM report, page 44.
Page 44. No, 44 is not there. Okay.
Case file is folded.
He is the sole accused.
Yes, sir. My lord, Caesar is, my lord, page 18, the murder weapon has been seized.
Page 18.
18, 1-8.
What is her age?
Age of
Okay, iron rod seized from the possession of this accused.
my lord, it has been recovered from the house of,
House of the victim.
no, my lord, the petitioner.
Petitioner means petitioner was residing in the same house,
No, my lord.
different
It was
house.
his first husband. The deceased was the first husband. And the my lord, petitioner accused was used to residing with the second husband.
Oh.
So murder committed at the second husband's house.
First husband's house.
No, madam. Second husband house.
The murder
The
is,
deceased was the first husband.
deceased was the first.
First husband.
Yes,
She, my lord, the petitioner used to reside with the second husband's house.
yes.
My lord, the crime scene occurred at the second husband house.
So why did the first husband come to the second husband's house?
My lord, as per the FIR, my lord, the deceased was called over phone by my lord, the accused.
Circumstantial evidence.
There
Yes,
is no I.
And body recovered from that place.
That
the,
place, madam.
The house of the accused.
Yes.
And the other thing is this, so the husband of this accused is not, the second husband is not made an accused.
No, no, no.
How many witnesses examined?
My lord, 5 out of 12.
Okay, 5 out of
Out
12.
of 12.
And she is in custody
2 years, 10 months.
2 years, 10 months.
And the next date is, my lord, 7th of December 2020.
Yes, take down. Learned advocate for the petitioner and learned advocate for the opposite party state of West Bengal are present. Hard learned advocates for the parties. Peruse the materials in the case diary. Learned advocate for the petitioner submits that his client is falsely implicated in the instant case and she is in custody for a period of 2 years, 10 months, and still 7 witnesses are to be examined. Learned advocate for the opposite party state submits that although submits that there are no statements under section 164 CRPC, but the iron rod was recovered from the house of the accused and the body of the victim was also recovered from the house of the accused. Upon considering the materials in the case diary and upon hearing the learned advocates and considering the fact that the petitioner is the female person and is in custody for 2 years, 10 months, we are of the view that as there is no reasonable apprehension to abscond and tamper with witnesses, in the interest of justice, the petitioner should be enlarged on bail. Thus, we allow the prayer for bail made by the petitioner. Hence, the petitioner shall be released with 2 sureties of rupees.
Standard
করা আছে। Petitioner shall not meet with the persons acquainted with the facts of the case. We have to দিয়ে দেবেন, the petitioner shall not leave the jurisdiction of the court and shall not meet the persons acquainted with the facts of the case. They meet any persons acquainted with the facts of the case.
77. 77. 78.
I am for the petitioner, Lordship. This is about the fight between the groups over a patch of land, Lordship. And fight between two groups over a patch of land, a land dispute, Lordship. And one suffered head injury and died subsequently, Lordship, and subsequently.
So some accused persons are on bail.
Yes, most of all, except me.
So when was your pair last rejected?
My rejected in June this year. But at the observation was it was 90 less than 90 days then. Now I am in custody for more than 225 days. All accused persons on bail, charge sheet.
What is the
submitted.
material against this
Charge
person?
sheet filed on 31st of August 2022 and present status is on 18th of November 24. His date fixed for production. appears
Some
on
accused
copy.
are on bail.
Copy has not been served upon.
Anyway, what are the statements?
Accused are on bail. Actually, another accused, namely Deodmar Hossain. His bail application, what I find, my lord, he is also on bail. In 161 statement, I find the name of this.
No, 164 statement.
164. Start.
Annexure page 17, annexure P4, there is an order of Honorable Justice Bagchi, Lordship. The order says that the principal, the 164 corroborates that the principal accused is one Anishu. Page 17, Lordship. There is an observation, second paragraph.
Yes.
I'm a local resident, same locality, I will face the trial, Lordship. এই যে 17 নম্বর paragraph।
ওরা বলছে ওই জন্য ওদের পাওয়ার যাই ওরা সেখানে আল্লাহ প্রতিবাদ করি বাবা
15 witnesses are there, Lordship.
So this present petitioner appears to be similarly circumstanced as this Chamidul Mias.
Chamidul Deonar Delwar Hussain. They have been granted bail.
Chamidul has also been granted
And
bail.
Delwar also granted bail. Delwar page 19.
The blow was given by one
Anishu.
Anisur.
Anisur bail.
Let him go, let him go. Hey, read.
এখানে যদি যে ডেট করেছে তার নামটা দেওয়া হয়
The petitioner says that the incident was a free fight between two groups concerning a land dispute. Stop. He is not the prime accused. Stop. Several persons sustained injuries. Stop. One of the injured persons succumbed to the injury. Stop. Hence the charge of murder. Stop. He is in custody for
225 days, more than.
for more than 225 days. Stop. Charge sheet was submitted in 2022.
Yes,
Stop.
in July 2022.
Stop. Charge has not yet been framed.
Copies have not been served yet.
Oh, copies have not been served even under section 207
Yes.
CRPC. Stop. There are 15 charge sheet named witnesses. Paragraph opposing the bail prayer, comma, the learned state advocate says that the charge is very grave. Stop. All efforts will be made to expedite the trial. Stop. Paragraph. Now, there is evidence against this petitioner. Paragraph, we have seen the material in the case diary. Stop. It appears that one Chamidul Mia, comma, a co-accused, comma, was granted bail by a coordinate bench by an order dated September 30, 2022, passed in CRM DB number 369 of 2022. Stop. In that order, it is recorded that one Anisur is the assailant. Stop. Other accused persons were present at the scene. Stop. It appears to us that the present petitioner, though was present at the scene, was not the prime assailant. Stop. Considering that even papers have not been supplied under section 207 CRPC, there is no likelihood of an early conclusion of the trial. So we are inclined to allow the petitioner's prayer for bail. Paragraph accordingly.
Allegation under section number 490, 494, 302, and 34 of the Indian Penal Code, Miller. Petitioner is in custody 567 days in custody, Miller. Miller, no progress in trial, Miller, no copies of nothing, Miller. Out of 7, Miller, 4 are on bail, Miller, and 3 are still absconding, Miller. No immediate charge, Miller. No immediate possibility of, Miller, the trial. 567 days custody, Miller. 14 years of marriage.
এই দেখুন এই যে ও not yes, the co-accused person is in custody.
They are bail, Miller.
Co-accused person.
Absconding for that, a warrant of arrest.
The under 498A and 302. The petitioner is what, husband?
Husband, Miller. Husband. The 567 in custody, Miller. No immediate trial, Miller. Last occasion direction.
Yes,
was
give
given, the direction was given to expedite the trial, Miller, but nothing hasn't programmed. It was directed, Miller, in the year, in the month April.
This person one. Maybe চার অবধি জেলে আছে 5 2 5 আর 6 অ্যাপয়েন্ট করেছে আর 7 হলো কাস্টডি। Okay, let us see the 164 statement.
What does the PM report say? Right. Naturally, there is no eyewitness.
How many years? The marriage after how many years from the
14 years,
solemn?
Lord.
14 years.
Yes, Lord.
Okay, let us see the postmortem report. Page?
106.
Yes, where is the medical report? The hospital ticket?
Page 125. Was taken to General Hospital from there to.
গায়ে আগুন লাগিয়েছে, তো লাগিয়ে দিয়ে গেছে একটা নাম। কি করতে হচ্ছে?
How many witnesses?
15 would take.
1 5.
So except this burn injury report and postmortem report and 164, there is no other neighbors witnesses? So for burn injury, there is no declaration, dying declaration before the hospital authorities or whatever it is.
Except what stated in 160.
164 is the mother of the victim. The death is due to burn injury.
Yes, okay, আছে বলা কি পানি যদি ফেরা অনেক কিছু থেকে ধরা গলা ফোলা দিয়ে করা মাছ করে বান্ধবী বান্ধবী দুটো হচ্ছে সুইসাইডাল গায়ে আগুন ঢেলেছে
Death, yes, death took place in the in-laws house. And who admitted her to hospital? Her husband. Yes, please take down. Learned advocate for the petitioner and learned advocate for opposite party state are present. Our learned advocate for the parties. Learned advocate for the petitioner submits that his client is falsely implicated in the instant case and is in custody for, yes, 1 year? How long you're in custody?
567 days.
Oh, but in custody for
567.
567 days. It is further submitted that 4 co-accused persons are on bail and 2 are absconding.
3 hours from the
Yes. Upon perusal of the materials in the case diary, the postmortem report, the injury report, it appears that the death of the victim took place due to burn injury. Of the victim took place due to burn injury. Upon further perusal of the materials in the case diary and the period of detention and the fact that trial is yet to start and 4 co-accused persons are on bail, this court is of the view that in the interest of justice, the petitioner should be granted an opportunity to remain on bail. Thus, we allow the prayer for bail made by the petitioner. Hence.
Not to leave, not to leave usual conditions, not to leave the judicial trial court, report to the local police.
80 million, I beg to appear for the petitioner, my lord, virtually, my lord. Lord, am I audible, my lord? Lord, I'm in custody for 311 days, Lord. The allegations are under section Lord 14A and 14C of the Lord Foreigners Act. Now, Lord, the petitioner's father.
Yes, Mr. Luksam, what is the maximum number of punishment? 14A and 14C? 5 and?
5 years.
5 years.
No, Lord, 14A, so for restriction.
Whether this court can take up this matter or should be taken by?
8 years. Minimum 2, maximum 8. No,
Lord, 14A, Lord, is 8 years.
Oh, yes, oh, one is 8 years.
Yes.
Lord, restricted area, Lord, that's the reason, Lord, it is 14A.
14C.
Since, Lord, the offences, alleged offence has taken place in
This
Kuchbihar, which
person is
is
an
a
Indian
restricted
citizen.
district. My lord,
Petitioner is an Indian citizen.
Lord, yes, Lord, why I'm saying so, your lordship would kindly take, Lord, page 17. Lord,
We have to call for a report, we'll have to give opportunity to the state to verify the documents.
as your lordship pleases, Lord.
That
The
is what-
only thing which I was, Lord, beseeching your lordship, Lord, to see that the petitioner's father, Lord, who, Lord, who was staying here, Lord, died in, Lord, in Calcutta. His death certificate I have also annexed, including my birth certificate. Your lordship would kindly call for a report, Lord, but and 3 of the accused persons, Lord, has been granted bail. One of the accused person, whom, Lord, it was alleged that he is also a Lord resident, is not an Indian citizen. He has also been granted based on, Lord, the documents of blood voter card. Now, since I have got blood Aadhaar card, PAN card, as well as birth certificate. Your Lordship would kindly see page 20, the order of blood, the other accused person.
It's 14A oblique 14C of the Foreigners Act of 1946. Stop. The petitioner says that he is an Indian national. Stop. He has on annexed copies of his Aadhaar card, PAN card, and birth certificate, in support of his claim. Stop. Paragraph. Let the state verify the authenticity of the documents and file a report in court on the next date. How long will you take?
বুধবার করে দেবো
Tuesday.
Tuesday it will be possible.
Paragraph. As suggested by the state advocate, let this matter be listed again on 12th.
Obliged. You come back on, deeply obliged.
I'm for the petitioner, Lordship.
Yes, my lord. 81.
Yesterday also fixed the matter of serious now.
So Monday, I'm on Monday.
Lord, in attitude to honor, I am for the petitioner. Lord, the petitioner before your lordship is a teacher in a government school. Now, my lord, he has a joint family, my lord, staying with brother, mother, everyone. My lord, his elder brother, my lord, had some hot altercation with a neighbor with respect to opening of a gate in a land. My lord, both are having joint properties, my lord, there, and hot altercation took place. And my lord, from that, my lord, free fight started between the parties.
What are the corresponding IPC sections?
My lord, section 302, 354, 74. 74. Lord, 302, 354 is there, 174 of BNS, Lord, I have to check.
Not 174, only 74.
Only 74. Lord, I just said 74. Lord, so, my lord, he went there, my lord, when he found that his elder brother is having a fight with the neighbor, my lord, he went there to stop them. And later on, my lord, the person who died, his wife also came, and then he was taken to hospital. Later on, my lord, he was declared dead in the hospital. So, my lord, this is the case in nutshell, my lord. I am in custody, my lord, for almost 57 days now. My lord, I am a person, my lord, in a government employment.
You have already been suspended.
My lord, perhaps by now I have deemed suspension 48 hours, my lord. But this is the case in nutshell, my lord. My role was only to stop them, my lord, stop the fight, and not to get indulged into fight.
That is what you say.
My lord,
Yes. What is there against this petitioner?
my lord, 164 statement of the wife of the victim is there now. Page,
That is the FIR maker.
page 64. Yes, my lord.
Complaint.
Page 64, my lord.
Abdul Dani.
আমাকে মানতে হবে তোমার মানতে হবে আমার আমি কেউ রাখি জলের জলে যাও জলের ফেলে যায় ওখানে মারতে থাকি
Charge sheet not filed.
Item still in progress.
Still on.
Postmortem.
You've been named, specifically named as joint assailant in the 164. Sorry, sir. Issue. The petitioner says that he has been falsely implicated. Stop. There was a dispute between his elder brother and the neighbor. Stop. A fight started between the said two persons. Stop. He tried to intervene and stop the fight. Stop. Later, the neighbor who sustained injury in the fight was declared dead in the hospital. Stop. He has no role to play in the alleged murder. Stop. Paragraph. Learned advocate for the state says that investigation is in progress. Stop. The petitioner is in custody for 57 days. Stop. There is enough incriminating material against him. Paragraph. We have seen the material in the case diary, including the statement of the victim's wife, recorded under section 164 chilo. TRPC. Stop. She is an eyewitness to the incident. Stop. She implicates the petitioner by name. Stop. Paragraph. In view of such prima facie involvement of the petitioner in the alleged crime, and considering that investigation is still going on, comma, we are not inclined to entertain the petitioner's prayer for bail, comma, at this stage. Dismissed.
I'm grateful.
About the petitioner. But the petitioner happens to be, my lord, the mother-in-law of the deceased victim. She is, my lord, the 60 years aged, and my lord has been residing in the state of Bihar.
Mother-in-law.
Mother-in-law, and has been residing in the state of Bihar. My lord, the alleged offense, my lord, committed, my lord, in the district of Coach Bihar. My lord, the fact remains that, my lord, that deceased victim, my lord, went to Coach Bihar, my lord, in order to, my lord, attain a family program. It is a relative house. She went missing for one day, my lord. A missing diary was lodged, and thereafter, after one day, his body was found from a nearby pond. It's floating.
She was a resident of which place?
She was a resident of, my lord, Coach Bihar.
Coach Bihar.
Coach Bihar, my lord. The entire crime, alleged crime, my lord, incident occurred in the district of Coach Bihar.
At that time, this petitioner was not in Coach Bihar.
She was residing in, my lord, Bihar, my lord.
And body was found from which place?
My lord, body was found, my lord, from Coach Bihar. From the relative's house.
After missing daddy.
All other accused persons, my lord, save and except husband, has been granted bail, my lord. Anticipatory bail.
Yes, what are the allegations against this person?
Mother-in-law.
No, allegation. Yes.
This is the, my lord.
No, is it a fact that she was not present at the scene of crime? She says she was in Bihar.
And it also narrates from the, my lord, the FIR, my lord, also. The first information report specifically states.
Yes, any neighbor statement that this lady was used to torture? There are no neighbor statements. No, regarding.
In? Only in FIR.
Save and accept FIR, there are no statements against this lady.
Didi? Issue. The petitioner is the mother-in-law of the victim lady. Stop. She says that she has absolutely no role to play in the alleged crime. Stop. She used to reside in Bihar, and at the relevant time, she was in Bihar. Stop. The incident happened in Coach Bihar. Stop. The alleged murder took place in Coach Bihar, and the body of the victim was recovered there. Stop. She is in custody for
31 days.
31 days, stop. She prays for bail. Paragraph, charge sheet not submitted.
No. Charge sheet.
Anyway. Uh, Paragraph opposing the prayer for bail, comma, learned state advocate says that investigation is in progress. Stop. Involvement of the petitioner in the alleged crime cannot be ruled out. Stop. Her name appears in the first information report. Paragraph, we have considered the material in the case diary. Stop. There prima facie does not appear to be any incriminating material against this petitioner. Stop. She is a lady aged about 60 years. Stop. We are of the view that her further custodial detention is not necessary so long as she cooperates fully with the investigating.
But she's the resident of Bihar. She has to cooperate with the.
She will, with the investigating officer. Stop. Accordingly.
I'm grateful to your lordship.
Thirteenth.
85.
But the allegations are under section 69, 88, 115, subclause 2, 351 of the SC of the BNS 2024. This is a case of
Corresponding to?
Lordship, this is false promise to marry at pretext of that. Lordship, I'll narrate the story.
No, under the new law, it is a punishable offense. Under the new law.
Lordship, since 2019, Lordship, the present petitioner and the victim were acquainted with each other. Page 27, 164 statement. My lord, I'll point out a few things. My lord, firstly, the complaint, my lord, that's appearing at page 21 of my application.
Page 21.
My lord,
Yes.
My lord, kindly come to page 23 and 24, my lord. My lord, the victim, she has stated her age to be 27 years, my lord. My lord, this is the electoral voters list.
Yes, which page?
My lord, page 23 and page 24, the verification in the affidavit, my lord, of her
Okay.
complaint. My lord, she stated her age to be 27 years. My lord, kindly comes to page 25 of this document which I'm handing over, my lord. Voters list, my lord. She is 38 years of age. She is a married lady having 2 children. One is 17 years old and one is 12 years old. She was having an extramarital affair with the present petitioner since 2019, suppressing the fact that she was married. With this present petitioner, my lord, in the year 2019, she moved out to Hyderabad. She resided with this person for 5 years. And when the present petitioner came to learn that she is a married lady, he denied that I cannot marry you till you obtain divorce from your previous husband. Now, my lord, this complaint is a outburst of that denial, my lord.
How long you are in custody?
My lord, I'm in custody for 21 days, 22 days, my lord.
Investigation is not complete, that
My
means.
lord, the complaint is false itself.
Yes, 161 statement.
Page number 27. My lord, in the complaint also itself, she has not disclosed that she is married. She has not given her husband's name. She has not stated that she has children. She abandoned her children. She abandoned her husband and went out with this man since 2019. After 5 years, she stayed with this man. They cohabited together. My lord, her allegation is on the false pretext of marriage. This person, the present petitioner, cohabited with her. My lord, may I be permitted to place the judgments of the Honorable Apex Court, my lord? There are 3 judgments which I would like to place before my lord. My lord, this is the 2003 judgment, my lord. My lord, this is this refers to Uday versus State of Karnataka, my lord. And this is the 2005 judgment, my lord. This is the 2023 judgment, my lord.
Is this the trial?
My lord, no, my lord, it's not the fact. My lord, it's an absolutely false case. There was no false promise of marriage, my lord. Rather, there was suppression on the part of the victim herself. She never disclosed that she was married or she had children. She happily went with this person since 2019. She resided in Hyderabad. My lord, the present petitioner is a Mason. She went with him and she worked with him. She resided with him there. And my lord, when this person petition comes to know that she's a married lady, this is the outburst.
বলছি দুটো ওর আগে একটা বিয়ে আছে, দুটো বাচ্চা আছে মেয়েটার।
Lord, kindly refers to the electoral voters, Lord, the actual age of the victim is stated there, Lord, on page 25.
See, that does not change the position. In both ways, she is a major.
She's a major.
Okay.
She's a major, she's married with 2 children. And all these facts were suppressed before the petitioner. On the pretext of this suppression, she left with the petitioner, abandoning her children and her husband. Well, this present complaint is nothing more than a counterblast. She simply got her suppression.
Yes, what is the medical examination report?
Yes.
Medical examination report?
14, page 14. Lordship, the complaint is also delayed. There's a delay of 4 months.
Separated and no extended genital embracement, hymen absent, vaginal placement sexual body defective, vaginal cell formation. ইনভেস্টিগেশন কোঅপারেট করবে, কলকাতা ছেড়ে যাবে না, কলকাতা না কোথায় যাবে না,
Jurisdiction of the professor.
whatever jurisdiction.
Without any condition, my lord, the strictest of conditions, my lord.
Yes, record your objection. Learned advocate for the petitioner and learned advocate for the opposite party state, respondent opposite party state of West Bengal are present. Hard learned advocates for the parties. Learned advocate for the petitioner submits that his client is falsely implicated in the instant case and the allegations made against the petitioner is not maintainable in the eye of law. Learned advocate further submits that the de facto complainant, being a married lady, suppressed the fact to the petitioner and he created a relationship which, when detected, made the de facto complainant institute the instant case. Learned advocate for the respondent state of West Bengal objects to the grant of bail. Upon perusal of the statement under section 164 CRPC and the medical examination report and other materials in the case diary, and considering the period of detention and stage of investigation, this court is of the view that further detention of the petitioner is not necessary for the purpose of investigation. Hence, the petitioner is granted bail. Thus, it is ordered that the petitioner shall be released on bail below it.
Last question, hence we are inclined to grant bail to the petitioner, subject to the petitioner cooperating fully with the investigating officer. Accordingly, not to leave the jurisdiction of the trial court. Report it once every fortnight.
Lord, in 86, I appear for the petition. Lord, the allegations are under section 14A of the Foreigners Act. and my lord, other allegations of forgery, etc. Now, my lord, this case squarely falls under a situation where, apart from bald allegations that I'm a foreigner, there is nothing on record to substantiate it. I'm in custody for 108 days, and my lord, the charge sheet has
You
been.
claim to be Indian.
Yes, my lord.
What have you produced?
My lord, the police has seized, my lord, kindly takes up, my lord, page 18. Serial list. Serial list. My lord, page 13. 13 is important. 1-3.
13.
13. The first line onwards.
Page kото?
Page 13. My lord, my original birth certificate, my Aadhaar card.
File a
my-
report, sir.
My lord, that has been done.
Oh, report has been filed.
That has also been done. It forms part of the charge sheet itself.
Oh.
Kindly takes up, my lord, page 18. Page 18, first paragraph.
Page 18.
Page 18, my lord.
Okay,
First
first-
paragraph, my lord, sixth line from the bottom. Further, I verified the ration card of Gautam Mandal from Habur Rahman, Sub-Inspector FNS of Kodiwadi Food Supply Office, KHB Block, and found to be genuine, as the card holder has completed his eKYC seeding of Aadhaar card number with ration card by means of biometric verification. This report invariably proves that the Aadhaar card of the accused Gautam Mandal is also true. Then it goes on to say that, however, I am sending a requisition to the Bangladesh immigration, but nothing of that sort has been received yet now.
So far, the verification of the documents is concerned, these are genuine. And he is deciding in this place, mentioning the cost title for how many years?
That is not very well. That is not very.
Okay, but so far the Aadhaar card is concerned, and what else? Ration card.
Certificate, other ration card.
Yes,
And PAN card also.
And PAN card also.
these are genuine.
All of them.
Any school certificate produced?
No, the birth
The-
certificate is.
Okay, birth certificate.
Birth certificate.
Yes, Judge.
No, with regard to others, those can be considered.
Yes.
The main allegation is 14A.
Yes,
The other, that is 420, 406 is there.
yes.
Yes, 468.
My lord, 468, 420, 470.
Yes.
Post document.
Yes, but
But
Documents are genuine.
okay.
Oh, very good.
So- Yes.
How long in
Mr.
custody?
my lord, 108 days.
Learned
Sorry, my lord, 230 days.
200?
230 days.
Learned advocate for the petitioner is present. Learned advocate for the petitioner and learned advocate for the respondent state of West Bengal are present. Are learned advocates for the parties. Learned advocate for the petitioner submits that his client is falsely implicated in the instant case and the allegations made against his clients are not maintainable. Learned advocate further draws attention to the documents which were seized from the petitioner, namely the Aadhaar card, ration card, PAN card, and the birth certificate. Upon perusal of the report, which is part of the charge sheet, it appears that these documents are genuine. So upon further, I'm just recording your objection.
Yes.
Upon hearing the learned advocates and considering the report submitted and the period of investigation and the fact that the investigation is already complete.
But report submitted with the supplementary.
Yes, whatever it is, investigation is complete. And the fact that the petitioner is in custody for 268 days,
230.
238 days, as there is no reasonable apprehension to abscond or tamper with witness in the interest of justice, the petitioner should be granted an opportunity to remain on bail. We thus allow the prayer for bail made by the petitioner. Hence, it is ordered that the petitioner shall be released on bail. Yes.
Not to leave division of Kodiwadi police station.
I'm for the de facto complainant, Lordship, in 87.
88. 88.
Not.
89.
I am for the petitioner in item number 89, Lordship.
Actually, the petitioner was engaged.
Have you given him a copy? Given him a copy? Then? Then?
Actually,
Keep it.
I-
এই এটা লিখে নাও করে লেখো affidavit filed by the petitioners in response to the rule issued by a coordinate bench, comma, be kept with the records. Stop, a copy of the affidavit has been made over to learned advocate for the state. Paragraph, list this matter once again on Tuesday. Tuesday তারিখ দিয়ে দাও।
as your lordship.
এটা ওকে দিয়ে দাও।
Lord, I'm for the petition in this matter. Lord, the petitioner, Lord, is praying for anticipatory bail.
Yes. 108.
दिन हो गया जिस दिन फाइल किया उस I'm for the state, Lord. Sorry, I'm for the petitioner.
You're for the?
Several times I've seen it. I love them for a time.
Acha.
Lord, case under section, corresponding sections of IPC, Lord, is 326 and 307. Lord, hot altercation between two groups with respect to a landed property, Lord. Neighbors, the family members of the de facto complainant, Lord, they are neighbors, as well as the petitioners, Lord, they are neighbors. So, with respect to a landed property, civil litigations are going on, Lord. Some altercation took place.
These are BNS. What are the corresponding sections?
Lord, 326 of IPC and 307 of IPC is the principal sections, Lord.
Yes, what are the injury
There is a
reports?
counter case. Lord, they have
How many accused persons are there in this case?
three. Lord, me, my wife.
The other two accused are on bail.
Yes. No, they are on bail, Lord. I have annexed the
Okay, let us see.
in my application.
He is the principal accused due to the assault. The petitioner has been partially paralyzed, lordship. Kindly see the injury.
But both the parties sustained injuries.
Yes, injury
We
report
have
which
also
place?
filed a counter claim.
Lordship, sir, page 33. The nature of injury.
Who suffered more serious injury?
Yeah, both, my lord.
We suffer. Which present victim?
All this happens in the heat of the moment, but there's no mainstream.
But the
We all know that.
My-
We all know that.
thing is, lordship.
Definitely not pre-planned,
Lord,
premeditated.
Lord.
Grievous
Your
injury.
lordship.
Still, it needs to be discouraged.
No, grievous injury with weapons,
Yes, lordship.
cut injury. Now let us see the victims.
One is hand totally broke. Can you see, lordship?
Yes,
And
page 33.
yes, lordship. And your lordships, main thing is when the source of information that the prisoner played was somewhere, when police had been to arrest them, their relatives beaten them. So they are.
But this is not something I have heard.
Lost, your lordship.
Against me.
No, against your relatives.
Lord, How can I be made culpable for that? My lord?
I think your worships, kindly see the injuries. It's a fit case for 307, your worship. One is neck, another is backside, and another hand is totally cut.
Don't look so serious. 4 o'clock on Friday.
No, what is the statement of the injured person?
Lordship, 164, page 120 and 114.
120.
Yes, your lordship. Specific name has attributed that this particular person. 120 and 164. 164 years, 120 your lordship.
Bail petition. এক নম্বর পিটিশন রিজেক্ট করে দিয়েছে 124.
My lord, 120.
120.
এইখানে anticipatory bill ছিল।
না না এটা নাসিরুল বিল না তো, এটা তো ও মানে নাসিরুল বিল রিজেক্ট করেছে এর মধ্যে একটা দিয়েছে
Charge sheet not filed.
No, no. My lord, all are absolutely.
So two accused persons were granted anticipatory bail.
But this.
But so far, this petitioner's prayer was rejected by the sessions judge on 7/9/2024. 7/9/2000.
This is a present petition.
So his anticipatory bail prayer was rejected.
Yes. And he is the principal. And his name is stated in the box.
দুটোকে দিয়ে দিয়েছে custodial interrogation to the doctor, never can. That is 302 only. Custodial interrogation doctor এখানে বলতে ওই এরিয়া থেকে না আরো যেখানে ঘটনাটা ঘটেছে এরা সবচেয়ে
খুবই কোঅপারেট করবে করতে we care করতে রিপোর্ট করবে ইউজুয়ালি যেগুলো আছে এগুলো করাই
এটা এইভাবে ইয়ে করেছে ওভারটা
এটা মনে হচ্ছে ইমিডিয়েট কাস্টডি সুতরাং এসি কোঅপারেশন
এরিয়াতে Yes, please take down. Learned advocate for the petitioner, learned advocate for the respondent state of West Bengal, and learned advocate for the de facto complainant are present. Are learned advocates for the parties, learned advocate for the petitioner submits that the dispute is dispute arose due to some proper land matter and the allegations made against the petitioner are not maintainable. Learned advocate for the respondent state of West Bengal submits that severe injury was suffered by the de facto complainant victim. De facto complainant is the victim.
No, no.
by the victim and the petitioner may not be released on anticipatory bail. Learned advocate for the de facto complainant also objects the grant of bail made by the petitioner.
The injury, his right hand has been paralyzed.
Upon perusal of the statement under section 164 CRPC and other materials in the case diary, although we find that there are allegations against the petitioner, but it also appears that two co-accused persons are released on anticipatory bail by the learned Sessions Court. As custodial interrogation of the petitioner is not required in this case, we are of the view that the petitioner should be granted anticipatory bail.
The injury is severe in nature. Can you see the photograph?
Thus, we allow the prayer for anticipatory bail made by the petitioner. Hence, it is ordered. Okay, two more condition. The petitioner shall not enter into the locality where the incident took place for a period of 6 weeks and shall meet the investigating officer twice a week and shall not meet the persons acquainted with the facts of the case.
Shall fully cooperate with the investigating officer. 6 weeks and all. Without the leave of trial.
Okay, so 6 weeks without leave of the trial court.
6 weeks.
Anyway, enter into the area without leave of the learned magistrate.
Right.
I'm for the petition.
I'm for the state.
The police arrested 4 persons, alleging that those 4 persons assembled together with an intention to commit dacoity. The petitioners are not there, they are not even FIR named. Their name have been transferred from the charge sheet. Now, Lordship kindly comes to the I have when the other accused person, those who have apprehended, they have already granted bail. And while granting bail, Lordship, this is the observation of the court that it appears prima facie that prosecution's narrative made out on the face of FIR does not attract the face value ingredients of the nature as alleged. So, the main culprits, alleged culprits, they have already got bail on the ground that there is no ingredient of these sections, and it is not the case of the prosecutions that they were flayed away. That's why they could not be apprehended. Not that. So, Lordship kindly comes to the FIR, that is page 12 of my petition, where they have stated on spot. I found above noted accused persons armed with sharp weapon in their hand in dangerous manner. On seeing police personnel, they tried to flee away, but after hot chase, we somehow managed to apprehend said accused persons. So nobody fled away. Those who tried to fled away, they have been apprehended and they have granted bail. We have come to the picture after filing of the charge sheet on the basis of the co-accused statement, which is
FIR doesn't name you.
Lordship. Even FIR does not make out a story to that effect that somebody were there, they were fled away. Nothing.
Lordship,
4 persons were there, 4 persons were apprehended.
Lordship, the name of the accused petitioner transferred from the jail interrogation, and he was present on the spot at the very time when a preparation was going on to commit a robbery. And moreover, Lordship, the charge sheet has already been filed in the month of February, and the Lordship kindly consider the conduct of the accused after 9 to 10 months. He remained absconding.
How will he know? How will he know?
From the
He is in the charge.
From the statement of the co-accused whose jail interrogation was done, who was apprehended at the spot.
Co-accused statement is admissible in evidence.
No, that's true, Lordship. During the time of investigation, it has a probative value, but after the charge sheet has been submitted, this is the statement of the co-accused is exculpatory, then it has no evidentiary value. This is true. But the other accused said that he was present on the spot.
The persons who were arrested from the spot have been granted bail by the learned trial court on the basis that even taken at face value, the FIR doesn't disclose the ingredients of the offense alleged.
Lordship, kindly consider my objection.
Yes, issue. The petitioner says that he has been falsely implicated in this case. Stop. Four other accused persons were apprehended from a particular spot on the alleged ground that they were preparing to commit dacoity. Stop. The petitioner was not present at that spot. Stop. The petitioner was also not named in the first information report. Stop. The petitioner's name first appeared in the charge sheet. Stop. The persons who were arrested have been granted bail by the learned trial court on the ground that the allegations in the first information report, even taken at the face value, comma, do not disclose the ingredients of the offenses alleged. Stop. Paragraph. Now, stop. The petitioner prays for anticipatory bail. Paragraph. Learned advocate for the state strongly opposes the prayer. Stop. He says that the petitioner was present at the spot but fled. Stop. Paragraph. Having considered the rival contentions of the parties, comma, and given the fact that the four arrested persons have been enlarged on bail by the learned trial court on the ground that the case made out in the FIR does not disclose commission of the alleged offences, comma, we are of the view that it may not be necessary. We are of the view that custodial interrogation of the petitioner may not be necessary immediately. Charge sheet filed, yes, of course, filed. Comma, so long as he cooperates with further investigation, comma, if any.
Lordship, not to leave the jurisdiction of the police station.
Correggio, not to leave the jurisdiction. Of which police station?
Mathabhanga police station.
Mathabhanga.
I'm grateful, Your Lordship.
One day.
13 Lordship, I am for the petition.
113.
30. 100. 30.
14.
I'm for the petitioner, Lordship. Lordship, allegation under section 85, 74 and 109 of Bharatiya Nyaya Samhita 2023, Lordship.
Corresponding to
section 498A, 354 and 307 of IPC, Lordship. Lordship, alleged fact is after a few days of the de facto complainant's marriage, he subjected to physically and mentally tortured by her in-laws and also assaulted by her in-laws.
These are in-laws.
Yes, Lordship. Father-in-law and mother-in-law is the petitioner. Petition number 1 and 2, Lordship. And they also tried to kill de facto complainant's son and also husband also, who is the another son of the petitioner, Lordship. So, and there is no criminal antecedent, Lordship, and it is not possible for the parents, Lordship, to kill their own son.
So 307 is there.
Yes.
Yes, what are the reports?
Regarding 307,
No injury report is there.
No.
Let us see.
general allegation, ma'am,
Husband is in custody.
was arrested.
Arrested and
Bail. For a bail. Yes, ma'am. Subsequently.
Son-in-law, brother-in-law already. got
Husband
bail,
is in
Lordship.
jail.
No, Lordship.
No.
This is the
One
first time.
person was arrested, subsequently, not husband.
Lordship,
these petitioners are father-in-law and mother-in-law.
mother-in-law of the de facto
De facto complaint. Whether her husband is in custody or
Husband is not,
husband.
husband is
Husband
not
is
made
not
an
accused, Lordship.
no, husband is not accused.
He is not the accused person.
The other co-accused brother-in-law is on bail.
Go ahead. He's on bail, Lordship.
Only bed head tickets are there, my lord, page 3 to 6.
So, but no injury report. Yes, please take down. Learned advocate for the petitioner and learned advocate for the respondent opposite party are present. Are learned advocate for the parties. Learned advocate for the petitioner submits that the petitioners are father-in-law and mother-in-law of the de facto complainant, and they are not involved in the instant case. It is further submitted that co-accused person is on bail. Learned advocate for the respondent state of West Bengal, although submits that there is no injury report, but objects the grant of bail. Upon considering the nature of offense, the materials in the case diary, the stage of investigation, and the fact that one co-accused person is on bail, this court is of the view that custodial interrogation of the petitioners are not necessary, and thus the petitioners should be granted anticipatory bail.
Charge sheet submitted.
Oh, Tali, considering the nature of offense and the fact that the investigation is completed, the stage of investigation, investigation is completed. As there is no question of any custodial interrogation, the petitioner should be granted anticipatory bail. Thus, we allow the prayer for anticipatory bail made by the petitioners. Meet the IO as and when. Oh, no question of IO. Shall attend court on all dates fixed.
Yes. Attend the court.
On all dates fixed.
Lordship, one indulgence, Lordship. In the cost title and in the petition, Lordship, I have stated that Bharatiya Nagorik Surakha Samhita 2023, that is instead of Bharatiya Nyaya Samhita.
Leave is granted to correct the person.
One day.
116.
Item number 16, Lord, item number 16, Lord, case diary has not yet.
116.
Petitioner will read.
17.
I'm for the slate.
Allotment has not been done, it seems.
No, I'm.
After the service and
Statement of implicated charge sheet submitted, principal accused and being liberty of bail, another co-accused also granted anticipated bail by this honorable court. Statement of co-accused. Yes, 15 is another co-accused granted anticipatory bail, my lord. And principal accused granted bail, my lord, page 17.
Page 17.
Principal accused granted bail.
That means from him there was recovery.
From him. And case 15 is my lord standing on the same footing. Statement of co-accused granted anticipated bail. Chapter is submitted, I will cooperate with this trial.
17 to no recovery. Go to principal accused on bail. Lord, from him there is no recovery, that is right.
Principal accused from whom it was recovered has been granted bail.
Oh. Roshan Lal.
Yes, ma'am, page 90, sorry. Page 90.
Issue. The petitioner prays for pre-arrest bail.
Medical ground. Anyway, on a different footing, medical ground,
Acha.
but from him there is no recovery, that is that.
Stop. He says that there was no recovery of contraband items from him. Stop. He has been implicated on the basis of statements made by co-accused persons. Yes?
Yes.
Stop. The person from whom recovery was made has been granted bail. Stop. Paragraph. He prays for bail. He prays for paragraph. Opposing his prayer, learned state advocate says that the principal accused was granted bail on medical grounds. Stop. However, he admits that there was no recovery from this petitioner. Paragraph, we find that charge sheet has been submitted upon completion of investigation. Stop. Therefore, there may not be any necessity for custodial interrogation of this petitioner. Stop accordingly.
Great.
This statement of void is no recovery from it.
Same. In custody. Yes, what is there against him?
Coaction statement.
Issue.
Investigation
Charge sheet
Investigation pending.
pending, he will cooperate. Issue.
এখানে দুটো আছে তো।
The petitioner prays for anticipatory bail. Stop. He says that there was no recovery of contraband items from him. Stop. He has been implicated on the basis of statement made by a co-accused person. Stop. He is prepared to fully cooperate with the investigating officer. Stop. Paragraph. Learned State Counsel, while opposing the prayer of the petitioner, says that admits that no contraband item was recovered from this petitioner. Stop. The principal accused is in custody. Stop. Paragraph. Considering the facts and circumstances of the case and that there was no recovery of contraband items from the petitioner, comma, we are of the view that immediate custodial interrogation of the petitioner may not be necessary, comma, so long as he cooperates with the investigating officer. Correct.
190. 190. 120. 120.
Which one? That's तारा के क्यों both side ready नहीं है?
121. 121, 122, and 122 allocated to me, but I couldn't.
Very well, not today.
123. 125. 126. 127.
126. There's no CD.
128. 129. 130. 131.
131, my lord, I am appealing for the petitioner.
नहीं.
Two occasions, my lord. Two occasions, my lord, the state is not there.
Okay, come ready on the next day, 131 and 132.
133.
Grateful, great.
134. 135.
Lordship, kindly bring that matter on Monday.
134. 136. Not today, ma'am. 137. 138. 139.
No, I thought the petitioner who was already granted bail.
Oof. Yes, who is appearing? State is not there.
I'm for the state.
Oh, you are?
Yes, I'm for the state.
You are ready?
No, my lord, actually, I've seen the order, my lord, but the case diary I have not received, and the.
Okay, that means how can you be ready without the case diary? Not,
Yes,
not today, not today.
140. 141.
Yeah,
140.
just consider if they are on the same footing. He's saying co-accused has been granted bail.
143. 144. 145. 146. 147. 148. 149. 150.
150, my lord.
151. 152. 153. 154. 155. 156. 157. 158. 159. 160. 161. 162. 163. 164. 165.
Lordship,
Yes, which matter? Both are ready? 168, yes. Yes. Next circuit, on the prayer made on behalf of the
165.
165. On the prayer made on behalf of the petitioner, did this application for anticipatory bail? No, it is anticipatory bail. Acha. Be stand adjourned till the next circuit.
Not today, not today.
167. 168.
Yes.
Yes, ma'am.
Long awaited. It's a matter pertaining to excise, Bengal Excise Act. There is, actually, the case is that the excise department intercepted a vehicle, the police intercepted a vehicle containing illegal liquors. And subsequently, the investigation was transferred to the excise department, that is the concerned authority. In course of investigation, they recovered the source where those things were kept and made subsequent recoveries. And after that, the source, I mean, the storage, the articles were stored in a compound. I am the owner of the compound. But the interesting thing is that I have actually entered into an agreement with one Borsha Enterprise. It is a registered small scale industry. The agreement entered into, the agreement is at page 25. This is the tenancy agreement. I let out the premises for to the industry, enter into an agreement. They will on the ground. They will prepare phenyl and other disinfectants in the there, and they have stored it illegally.
Mr. Vishal,
All the other accused persons.
they will have to verify the authenticity of this tenancy agreement also. Maybe an eyewash. They'll have to.
Not all the other accused persons are on bail. Those who were arrested from the spot were all granted bail. I am the only one appearing before your lordship. Investigation has progressed a lot. Caesar has been affected.
No, their recovery was from a particular vehicle.
No, from us recovery.
From your.
I am not there.
No, from the premises which is owned by you.
Owned by me, but there is an agreement, and the agreement shows that I let out the agreement to the industry. They took it for preparation of phenyl. And illegally they stored the
Yes,
product.
what is the report?
My lord, at present, my lord, the case, my lord, charge is pending. They have collected the, my lord.
It is in the CD, lordship.
Agreement between this landowner and the person who was other accused, my lord.
No, the place, the place from where it was seized. Did you interrogate any of the persons, those tenants and all those persons?
Yes, my lord.
They were in custody, lordship. They were ultimately granted bail by the court.
Let us see.
At page 20, lordship, those were from the factory, those were arrested were granted bail.
161 Page 5.
And the document I have annexed that has been seized by the.
Notarial agreement of the same.
Yes, so
Okay.
therefore,
During the
there's
investigation it was
a
seized.
Notarial agreement was seized.
genuine tenancy agreement. And you arrested the tenants, let us say.
Tenants, right.
They have now been granted bail.
Yes, lordship.
So they were in physical occupation of the
Physical
premises.
occupation, yes, my lord.
And he may be the owner, but he was not there.
He was not there.
So he will, charge sheet is pending.
Charge is pending, my
He'll
lord.
cooperate with you.
Correct, lordship.
Esho.
I will cooperate with every terms.
The petitioner says that he has no connection with the alleged crime under sections 46 capital A bracketed C, comma, 46 capital A bracketed double C, comma, 46 double A, comma, 52 and 61 of Bengal Excise Act. Bengal Excise Act, bracketed Moinaguri Excise Circle, bracket closed, penal code. Stop. He says that recovery of illicit liquor
Yes, lordship.
was made from a property which no doubt is owned by him. Stop. However, he has let out the property on tenancy under an agreement dated.
Agreement dated.
30th
October.
2023.
Huh?
30th October 2023.
October 30, 2023
It was seized by the investigating authority.
to
One Bikash or.
one Bikash Urao.
Urao.
Urao, Bikash Urao. Stop. The said Bikash Urao took the property on tenancy for using it for manufacturing phenyl. Stop. The petitioner was not in physical possession or occupation of the property from where seizure was made by the police or excise people.
By the excise people.
Excise.
By the-
Subsequently excise.
by the
Police
excise
initiated the
people.
case.
Stop. The persons in occupation of the property were arrested and subsequently enlarged on bail. Stop. He is prepared to cooperate with the investigating officer to the fullest extent. Stop. He prays for anticipatory bail. Paragraph. Learned state advocate, while opposing the prayer, tells us that a notarized copy of the tenancy agreement was seized by the excise people from the property in question. Stop. It is true that the petitioner is not in physical control of the property. Stop. Paragraph. In that view of the matter, we are of the opinion that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the investigating officer fully. Accordingly,
Offline. Yes. Yes.
428. Chalo, chalo. Who is for the other side? Dekhe do.
Intimation served, madam.
179.
41A.
No, man. POXO case, madam.
Oh, it's a POXO.
Lordship,
Intimation served.
Lordship, these,
POXO, it's a bondo karo, baba.
Service is affected.
Yes, madam, through IO.